So I think the main point that I'm trying to make here is that it felt like the Trump administration was trying to usher these people out as quickly as possible without notice of without notice of their ability to challenge their deportability under the Alien Enemies Act, because the Alien Enemies Act proclamation hadn't even been made public yet. So how do you challenge your deportation under an order that hasn't been ordered yet?
They may not have had the opportunity to challenge. Yeah, sounds good on my end.
All right, perfect. Okay, are you ready?
Yeah, I mean, yeah, I thought we were just having a discussion. I saw you had a debate, but I'm here to talk about it, so I'm ready for whatever.
Debate brings in the views, all right.
Yeah, no, you're all's fair. All is fair. I don't mean to throw you off or anything. I'm just saying.
Yeah, no, you're good.
Because I'm just coming in with my understanding of due process, and I'm like absolutely open to hearing what you have to say about it.
Okay.
Because you responded to my video, so I was curious if there's something in the video that you thought maybe was like a bad analogy or that you disagreed with, and we could maybe work from there. But I'll let you open.
Yeah, so I think that the way that Trump is engaging with the due process rights guaranteed in the 5th and the 14th Amendment is pretty bad faith. I think that they were robbing them of the opportunity of the notice for the ability to challenge their detention and the actual ability to challenge their detention, which is the way that I think due process is typically defined in immigration, is the ability to challenge your detention and to challenge your designation as deportable. I think Trump was trying to move so fast to where the judicial basically couldn't keep up with the deportations. And I think that your video, as it relates to you, kind of missed the main criticisms of Trump's administration. I felt like it would have been very helpful to go into the specific cases and the specific claims that people are making by which somebody was robbed of due process. I know that you brought up Kilmar Abrego Garcia. I'm willing to go into that case as well, but I think
sure.
When people talk about removing due process rights, they're typically talking about the JGG class action, and I think that
JGG class action. Okay, I'm not super familiar with that. What you're referencing there?
Yeah, there's a so that's the class action of the people that were challenging their deportations under the Alien Enemies Act.
Okay, that was the case that. Okay, got you.
That Boasberg was presiding over.
Got you. Okay.
I think that case shows a much more willing disregard of these people's due process rights. Based off the timeline, we can go into either case, but I'll leave that up to you.
Sure. Well, I disagree. I think this is perhaps maybe due to our understandings of due process as well as habeas corpus and what rights you have to challenge in court. So maybe this is relevant, and I'm not coming at this like I'm an attorney, but I'm not an immigration attorney, and I'm certainly not an expert on the topic. So I'm not trying to come at this, but this is just my understanding of the legal side of it.
Mm-hmm.
So a citizen has a habeas corpus right to challenge the constitutionality of the law that they're being held under, right?
Mm-hmm.
Even without that right, these citizens still have non-citizens that are being deported, even under the Alien Enemies Act, have the right to challenge the facts of their case, like their identity, whether they are that foreign national that they're being accused of being, whether they're a part of this dangerous gang. Abrego Garcia, as an example, I would say we did make a mistake ignoring the withholding order. That's been established. But if that withholding order hadn't been entered, he would have been validly deported under the due process that does exist, right? So what I'm pointing out there is the hyperbole of saying he received no due process. He received an errant due process, sure, but I think we ultimately would have had the same result anyway. And when it comes to due process as it relates to immigration, my position is that the issue with due process in our immigration right now is that it's made it so that the government cannot efficiently enforce the law. And under Supreme Court case law, this is a consideration in due process. Not the only consideration. It's not like a slam dunk or anything by any means. But there is something to be said about the level of due process being afforded right now that is actually preventing us from enforcing these laws that engage with deportation as a civil remedy for the civil offense of being here illegally.
Mm-hmm.
So I think we would both agree. I want people to be able to challenge the facts of their case. I don't think non-citizens can challenge the law and the Constitution. They don't have that right? They're not. a citizen of the system that's created there. But they should absolutely have the right to say, hey, you have the wrong identity. That's not my name. I'm not from that country. I'm not a member of this gang that you're accusing me of for the Alien Enemies Act, for example.
Mm-hmm.
I agree with all that. And as far as I'm aware, even under the Alien Enemies Act, they have those rights to challenge those facts.
Mm-hmm.
But they don't have the right to challenge like the constitutionality of their holding or deportation. And I don't necessarily disagree with that. And as a Trump supporter, I would say Trump was elected to solve this problem of immigration. And one of the problems is that we have no efficient way of enforcing our current immigration law. So I want people to be able to challenge the facts of their case. I don't want errant deportations, right? But what I see happening, I think, is being taken out of context. It's a bit hyperbolic.
Mm-hmm.
I'm all about having eyes on the system, so I'm not upset about it. I'm happy we're having this discussion and stuff. But from my position and my observation as a Trump supporter, this is actually in line with what we voted for, and in line with what my understanding of due process is.
Yeah, so I mean, I'm glad that we agreed that these people do have the right to challenge their classification under the Alien Enemies Act, because I talk to a lot of Trump supporters. Granted, I'm a TikTok debater, so I mean, a lot of the people I talk to aren't going to have as good an idea as people who do this for like a hobby. I noticed that you wanted to jump in. Go ahead.
Oh, well, I was just saying, they can challenge their designation under the Alien Enemies Act. They can't challenge whether like it's a constitutional designation, right?
Right. Yeah.
Does that make sense? That okay. So yes, I agree, and I do support. Let's forget the word due process and just kind of replace it for the sake of this conversation, for our understanding, with like due diligence, right? We both definitely agree that the government should do its due diligence, right? Then what that means is what due diligence means. I mean, they need to check all the boxes, do everything the correct way. And that's what I believe due process means. But this doesn't mean that we can't adjust it or make it so that it's more efficient for us to enforce immigration law. You should always be able to challenge the facts of your case. And even in my understanding, even under the Alien Enemies Act, you can challenge the facts of that case. Yeah.
Yeah, I wouldn't say that due process means that every single person needs a court case. I mean, like in the previous usage of the Alien Enemies Act, I think for the Japanese immigrants in World War II, their due process was settled by an alien enemies hearing board, where you basically go in front of a board of people and you're able to challenge your detention that way. And then if you're deemed to be under the Alien Enemies Act, then you could be deported, and that still complies with your due process rights. So I guess the problem that I have with what the Trump administration is doing is if we go by the facts that Boasberg found in the Alien Enemies Act, and if we go by the allegations by the plaintiffs that I don't think were contested by the government, because they were basically saying that we don't have to challenge these. So if you want to throw out the details, that's fine. But from what we know about these deportation flights, they were rounding up people before the proclamation of the Alien Enemies Act had even been public. Donald Trump signed the proclamation on the 14th. It became public on the 15th, and then JGG, the named plaintiff in this case, ended up being captured on the 14th and was put on a plane to be deported on the 15th. So we're talking about rounding up plane loads of people. I think there were three plane loads that got shipped off within not even 24 hours. Before the proclamation had even been public.
How did they select? So I didn't mean to cut you off. I'll let you. That's my bad.
No, that's it. Just these people were trying to be shipped off in less than a day before the proclamation had even been publicized.
So my question, and I'll admit I'm not as familiar with this case. I haven't read up on all of this stuff. I came to this with just my basic understanding of due process, basically. But how in these cases, you said there's three plane loads of people. I don't know how many people, say 100, maybe but let's just say 100 for the sake of my question. How did the government select those 100? Right, they didn't just go pick 100 people that were the closest illegals to them, right? What were these people they were on some list or something, or they had some sort of designation prior? How did we select or choose those people that got sent on those flights?
So a lot of these people were oh wait, hold on, there's somebody spamming.
No worries. Because that's just my first question is is it that this is a list of people that we've had sort of pending orders against, or that we've established something in a court of law prior to the deportation? Because it would be, if it was this is the first instance that they've had, this interaction on the 14th they had, was their first interaction with the law in this sense, right? That would be more convincing to me than if it's like all of these people that got, kind of rolled up in this, 14th, 15th thing that you're describing were already on, some list, or were already, maybe subject to deportation, or were pending some sort of like final hearing that is no longer necessary with this change. So those would be
my understanding is that it was I don't know if there was one uniform process by which ICE was detaining these people. I know that JGG, for instance, I think was detained on the 9th of March while awaiting his asylum hearing. There was 4 other named plaintiffs, but they went by pseudonyms. But like all 5 of them had a different story of like why they were captured by ICE, and then why they ended up being subject to the removal under the Alien Enemies Act. So I don't know if there was like a uniform, and obviously like the details about how they captured Kilmar Abrego Garcia is separate as well, because he had, previously been litigated as a member of MS-13 by an immigration judge. So like their want to capture that, or, I don't know what the technical word is, but like arrest him and then challenge his withholding order, theoretically, I think that was probably the aim. Would be different than like JGG, who was awaiting asylum, or the other 4 guys who were captured for different reasons.
That's true.
I don't think that there was a uniform process by which these people were grabbed, but it's also hard to tell because JGG was a class action. So I mean, we only have the details of the 5 named plaintiffs, but there are like this encompasses a lot of people.
And this stuff's all still pending, so we don't know how this will resolve. But I do hear what you're saying. I'm not trying to dismiss it, but I do think that we will have to wait in some sense and see what happens with it, with that case, assuming it's still pending. Like I said, I'm not coming in with any real, deep connection to that case or knowledge. I know that they ruled some pending hold on the Alien Enemies Act, temporarily allowing Trump to enforce it. Is that right?
JGG got dismissed because they ruled that a class action wasn't the right venue to challenge your detention. It has to be done through habeas corpus. Yeah. But regardless, I still think that some like the information we got based off of like the deportation from Boasberg is useful information, even if the case ultimately isn't going to play out because of venue.
Right. So, well, that's a venue jurisdiction decision. I guess it'll have to be relitigated somewhere else. Mm-hmm. And I don't know how quickly that'll happen, but I guess like as far as the examples that we've gone through, these 3 flights, these were all to the same place, or these 3 different flights?
All from an airport in Texas near the border to El Salvador.
Okay. This is the Abrego Garcia was on these flights.
I don't think he was on these flights. I think he was a separate case.
Okay. So okay. Well, all of these people, I presume, would have had to have been validly deportable to El Salvador. And I say that understanding that we obviously have one example of an error being made where this person was not supposed to be deported to El Salvador. So I can grant that. But in theory, that is the issue. And with, I guess, sort of the transition, because I guess we're going to cover this at some point, because one of the things I've been hearing is like, oh, Trump has to, facilitate this return or else.
Before we move on, can I just address one thing?
Yeah, sure.
So, oh wait, hold on. I lost a thought. Wait, 1 second. I need it.
No worries, dude.
Fuck, what was I gonna say?
Maybe
the reason why these people, or like the legal justification for these deportations was the Alien Enemies Act. That's why these people were being arrested. It was because of the order. But my problem is that I don't think that comports with like what we understand immigration or like illegal immigrants' due process rights are, because it's my understanding that you need some sort of notice of like deportability, and the fact that they were being rounded up on the grounds of a proclamation from the president that hadn't even yet been made public, feels like
it's not the type of law that you can enforce where you give everyone notice that they're going to be like, do you think that we could just say, hey, come turn yourself in, we have a warrant for you to come to this hearing? Do you think that like that would be an effective way to get these illegal immigrants to come to these hearings, or subject themselves to the due process that we want them to? Because I think a lot of the times they're not even subjecting themselves to the due process that we want to, and that's another one of the problems. They don't show up, they fail to appear.
We can look at what like specifically due process would mean under the Alien Enemies Act. Like even if they were doing something akin to the way that we were treating the Japanese immigrants under the Alien Enemies Act, that would be okay. But my problem is that they at least got the ability to determine, hey, I'm a member of this gang, or I'm not a member of this gang, or I'm a member of this,
Right.
I'm deportable for this reason, but I'm not deportable for this reason. Whereas here, it felt like the character of what Trump was doing was basically getting all of these people on planes as quick as possible without any sort of litigation or any notice that they're able to even challenge their designation.
So it does expedite the process. It reduces the number of hearings that they can challenge, right? Because like they lose the habeas corpus challenge, right? What it doesn't mean, and what my understanding is not, and I might actually would be on your side of this issue if I was wrong about this, but even under the Alien Enemies Act, they do have the opportunity to challenge the facts of their case, as in their identity, their membership of a gang or threatening group that would, qualify them under the Alien Enemies Act. And so they still have a process. It's not as extensive as the due process would be for a non-citizen who maybe has no, association and isn't from an enemy state or falls under what the Alien Enemies Act applies to. But it doesn't remove the due process, and it still does require, it requires the facts to show that these people are, a threat. That's all still part of this process. So it's a maybe truncated process, but it's still due process. And it's still, I think, as a citizen, a way that I would like to see our immigration enforced, especially given the levels of due process. It feels like there's so many levels of due process. It's really hard to imagine anyone getting deported. I know a lot of people in my life that, I live in Maryland, so we have maybe a higher population than some places, but I know a lot of people here. I know people that are here illegally. You know what I mean? And I have never once in my life thought oh, I wonder if they're going to get deported. I'm not worried about for them.
So,
right? They're not criminals. They're just, going about their lives and stuff. And I don't know, maybe that day will come, I guess, but it's I don't see how due process isn't actually if I were making the argument on due process in front of the court, I would argue under the Matthews test that we have to adapt our due process to make it a lot more efficient.
My problem isn't...
Whereas it seems like driving towards efficiency is an affront to due process from your position.
Yeah,
it feels like that.
Yeah, my problem isn't even the level of due process that is allotted through the Alien Enemies Act. That's not my concern here.
Okay.
My concern is that even the due process that is allotted through the Alien Enemies Act doesn't feel like it was being followed by the Trump admin. So people who are subject to the Alien Enemies Act know that they can challenge in this way and know that this is what's happening and this is what they're deportable under. But the problem is that they were rounding these people up before the proclamation of the Alien Enemies Act was even public. They don't even know that the Alien Enemies Act is something that they're deportable under because the Alien Enemies Act executive order hadn't even been publicized yet. They don't know that they can challenge their detainability because they don't know, or deportability because they don't know why they're being rounded up for deportation this quickly.
But it's not necessarily true that the Alien Enemies Act changes the outcome of whether they're deportable or not. It just changes how that process works, and that process requires showing that they're a threat, that they're a member of a gang or some other enemy state or something like that.
Sure, but I mean, in the case of JGG, he's already going through immigration processes. He's awaiting his asylum hearing, and then he gets detained, and then the only reason that he wasn't deported was because the plane malfunctioned, and that's the reason why this case even exists, is because his deportation got put on hold. But he's going through the process right now to challenge his deportation or stay in the United States. He's going through the legal process, but there's a new legal thing that would make him deportable, that isn't public, that he's, for all intents and purposes,
this challenge that we're
would have been
describing
deported for.
I mean, he got a Supreme Court brief. I mean, he's getting due process, right? He got the Supreme Court writing in response to his case. That I don't.
Yes, but
that's a rare thing to get, the Supreme Court. I mean, but I'm just saying respectfully, it does feel like we are affording this due process. And I know in the Kilmar Abrego Garcia, we have this example where we made the mistake, and it was the mistake's already been made, and it's too late to facilitate his return. It's up to Bukele, and my boy's not, I get that all for sure. But in these cases, it's just this. I do feel like it's still a little bit hyperbolic to act as though due process itself is being affronted until you can convince me that we're no longer allowing people to challenge the facts of their case. This example on the 14th, the reason I think it sounds convincing to me and could convince me is because it sounds like the 14th is the first time like this process started for them. Like it was like a shock and like a sudden thing. But you're telling me like they had like a pending asylum cases and that they had been going through processes. I mean, it sounds to me like was the asylum denied? Like they denied it and then they said, okay, now you're subject to removal under this act, and now that you don't get this habeas corpus hearing, and you don't get to challenge this. But
this person was awaiting his asylum hearing when he was detained under the Alien Enemies Act. So he hadn't been like ruled deportable yet. He was going through the process.
Well, and to be fair, like I said, I'm not an expert attorney in this area, so I don't know. But like, I don't know that when you apply for asylum that you're guaranteed to be held throughout that process. You might not qualify to even apply. I don't know how it works. Like that's why I'm saying I don't know. I'm an expert, but what you're saying would be convincing to me if it was assumed that anyone who applies for asylum is granted like a temporary pause in proceedings. But I don't know that that's the case, and perhaps it is.
I don't
believe
that's the case, but I would say that like if somebody's going through,
it could be the case.
I don't believe.
I have no idea. I'm just saying.
I personally don't believe that's the case. But regardless, so I think the main point that I'm trying to make here is that it felt like the Trump administration was trying to usher these people out as quickly as possible without notice of their ability to challenge their deportability under the Alien Enemies Act, because the Alien Enemies Act proclamation hadn't even been made public yet. So how do you challenge your deportation under an order that hasn't been ordered yet?
They may not have had the opportunity to challenge their deportation under that order. What they would have had the ability to challenge is that whether they are an enemy alien under that act that is engaged in a gang or as a member of a foreign state or whatever the wording is of the Alien Enemies Act. Mm-hmm. Like the Alien Enemies Act changes the process and it does speed it up. And there's no doubt that the Trump administration is trying to use it even in a bit of a stretch legally, right? To be like the Alien Enemies Act, like, it's generally, in theory, you could argue reserved for like serious wartime, right? Mm-hmm. But this is common in law, and we've seen this is certainly nothing new in legal space that we have stretched interpretations of things. The Supreme Court has, I don't really want to talk about the Commerce Clause, but the Supreme Court's fucked us over so many times. Mm-hmm. So we have to see how all this goes, but I guess I'm sort of losing my train of thought, but I guess to share that passion with you and identity with you, we do, I think, agree and would side together on people should not be rounded up and deported without the ability to challenge that they are deportable. Mm-hmm. And what that means is that they are who they say they are, that they are a foreign national, and that the law demands that they are deported, which would also include that they don't apply for any sort of exemption, right? That's the due process that we offer them. Mm-hmm. What I disagree with, I think, is that what we're seeing as we make this system more efficient and operate faster is an abandonment of those principles. We're seeing due process change, and due process, as the Supreme Court has said, does account for the government has to be able to effectively enforce law. That is a consideration. We're talking about the due process that the government has to afford you. So in cases like this, where I would argue it's become nearly impossible to enforce our immigration law, the demand is actually to make it more efficient, which does not mean abandoning the principles that we identified as shared principles, identifying that these people are, in fact, subject to deportation under the law.
I guess I can't ask you this question because you're not as familiar with the details of the case, but then my question would be is what sort of due process were these people even allotted? Because if you're not given notice that you're able to fight your detention and fight your deportability status under the Alien Enemies Act, because you don't know that you're being deported under the Alien Enemies Act, then I don't think that that constitutes like a due process.
I just don't understand how we know who to deport and round up under the Alien Enemies Act if we've had no process take place before that. You know, like how do we know how are we rounding up who are we rounding up? Where are we getting these people? Like how do we?
I think it's just going to be based off of ICE's determination that you are a part of this group. So I mean, like I know a lot of the cases were dictated off of the person's tattoos. Specifically in JGG, like the JGG was a tattoo artist, and he saw like certain tattoos that they claimed were aligned with Tren de Aragua, and that was the grounds for deportation under the Alien Enemies Act.
Well, I won't argue that because that's a whole forensics thing in criminal law. That's like, I mean, I don't even think that's really illegal. It's like cops and law enforcement stuff. So I don't know all about like that stuff, but.
So basically what I would say is that, like, instead of just going based off of, like, ICE's, like, designation of this person as a gang member, I would think that we should be affording this person notice that they're deportable, or at least, like, way more substantive notice. Well, I believe that we still are. It may be quick. I reject that in this case we did.
In the JGG case?
Yeah, or like the Alien Enemies the first road on
March 15th. I guess we'll have to maybe revisit this another day because I'll look into it and see what I can figure out about exactly how this processes work. Because what I'm struggling to get through here, and we don't have to sort this out right now, but is how we have a list of these people. Like that we're deporting under the Alien Enemies Act, right? Like if we have, like the thing passes on the 14th and it's happening on the 15th and they're going out on the 14th and rounding people up that they know are going to be subject to this order. Like how did they know that they were going to be subject to that order without some, like, I guess what you're maybe calling into question is the validity of those ICE determinations, which I'll agree is probably not as accurate as the like full hearing process would be. But I don't know how accurate or inaccurate that system is. I don't know how much it's supplemented by a hearing, right?
Basically, what I'm arguing is that the ICE designation of somebody being a part of a terrorist group alone shouldn't constitute their due process rights. I think that they should have the ability to challenge.
Well, it depends on. I guess it depends on how that determination is made, because there's probably some cases where if you and I were to go and sit down and look at their case file, we'd be like, oh, this guy's like, holy shit, yeah, get him off the streets now, right? Mm-hmm. And then there's some cases where we might be like, what, like all you have is tattoos and like an association, like. How do you know he's not just like involved with them because he's like a low town drug dealer, right? How do you know he's involved in MS-13 and like at this high level and stuff? So I mean, I agree with you on those principles for sure, and like that's forensic stuff, and it's a bit separate, I think, than the due process question, because now we're talking about how like the police and evidence is recorded for those hearings, because regardless of the hearings, all of this stuff is still looked at. Like even all of these designations with the tattoos and stuff is signed off by the hearings that we would be talking about.
Yes, but the problem is that like we hadn't let this play out in court, and I don't like the idea that someone can be basically detained by ICE on the grounds that they have like things that allow the ICE officer to designate them as a part of this terrorist group, and then the next day they can be on a plane getting ready to be shipped off to CCOT. I think that there needs to be more opportunity for these people to challenge that status, especially when the only reason that JGG ended up becoming a case is because of a malfunction with the plane that didn't let them move as fast as they wanted to.
Right. Well, no, that's interesting for sure. I guess it comes down to what, like, because I mean, I guess we're on different sides of the political aisle here.
Yes.
So when we talk about immigration law and deportations and stuff, do you want to deport all of the people that are here illegally? Because I think maybe that even is kind of like subconsciously playing into here. Maybe not with you exactly, but I'm just saying, like, as a social discussion that's happening in the country, it almost feels it's like some of the arguments being made are like Do you just don't maybe necessarily share the same interest in having an efficient and effective system that actually deports people that are here illegally? Because I agree with you that I don't want this to be willy-nilly, random, just just do it really quick so like any errors just can't be caught and all that stuff. Like I agree with you with all those principles and stuff, but I think I am actively trying to figure out how to develop this due process system to honor the constitutional due process rights that we have, while efficiently and effectively actually deporting people that are subject to deportation without it taking 6, 7, 8 years. So an expedited process is actually something that I'm looking for, as long as it doesn't abandon those principles. And so, you'd have a good we can keep talking about this. So this doesn't have to be the only night we ever talk about this. But like, if we look into this later and like we see that like, hey, these people really aren't getting a chance to even challenge the facts of their case. They can't even like challenge their identity. They're being like, identified and rounded up based on tattoos and being in the wrong place at the wrong time, and they're really not getting those chances. I would be more willing to side with you, but I don't see that that's what's happening. I do think that these people are getting rounded up. They have an expedited process. They're still getting a hearing where they can challenge those facts, and because they're non-citizens, because they're subject to this act, they don't have the same habeas corpus rights to challenge the validity of the act, which is like a legal distinction, I guess. But in principle, I am actively looking at the system, seeing it as a broken system. The due process system is broken. I think it's just broken for me from the other side, right? Like I'm saying, this is too bloated. It's offering like, I don't want to say too much due process, because it's not like it's like the rule book. Like the government has to follow the rule book. So like, it's just that we need a system that's efficient. But do you share that interest, or are you kind of actually interested in like eventually changing the law so that we don't have deportations, and so maybe we don't need to effectively speed up these deportations? Because that's a fair position to have for some people that oppose our current immigration law. So I guess I'll just throw it back at you and just like, where do you stand on like that question?
Yeah, so I mean, this might be kind of an unsatisfying answer, but like most of the political engagement that I have falls not even necessarily with the social politics of it all, and more so within like the, I want to make sure that our rights aren't infringed. You can call me like a libertarian if you want to. I like making sure that laws are followed, that we have like a general respect for how these processes go forward, and if there was like a meaningful contest to the way that these are going forward, a meaningful legal contest to the way that these were going forward, then that would be a completely different question. And I don't even know if I would be here talking to you if it was just that Donald Trump wanted to deport a lot of people. Personally, I probably don't agree with that aim, but that's not even something that I'm necessarily interested in arguing, as much as like necessarily the fact that the designation of these people as TDA, or the designation of certain people as MS-13, just by ICE alone, without the ability to challenge the designation, is
the claim
is
there,
the
saying
main reason
just by
why.
ICE alone.
Well, that's what.
That's a claim that you're making there.
Yeah, that's what it seems.
Are there no judges or hearings signing off on what ICE is presenting?
So from what I'm aware of in the case, I could be wrong, but it does seem like the only thing that was designating these people as TDA members was ICE's classification of them as TDA members.
Well, that would be the only evidence that was provided to the court was from ICE and involved what you described. But that doesn't mean that the ICE is the one who made that decision. They would have provided that evidence, say that's the only evidence that the court had, and they said, yeah, you're right. That's with that only being the evidence, we go off that. Is that what you're on the same page?
Can you rephrase what you said? I'm sorry.
So like you said, ICE alone, but I'm making the distinction that it might be ICE alone in the sense that the court only has evidence provided to them from ICE, but that doesn't mean that it's ICE alone that like signs off and allows that determination to be valid. The court is still making an analysis based on the evidence. In some of those cases, the only evidence we have is ICE, which I think actually makes sense with people who are here illegally. We don't necessarily have records on that. It's undocumented, is right. Like they're just not documented.
I guess the distinction that I would draw is that if you're not giving these people the ability to go through the courts, then we have no way of knowing if it's just ICE's designation or if there is other like circumstances to know whether or not this person is a part of TDA. Because I don't believe that we rounded up like hundreds of people to ship them off on plane loads within a day and like had like a strict vetting process.
Database of known. I mean, isn't it and I'm not in law enforcement, so I'm not asking this to gotcha. I have no idea. But like, and this is just my like layman's understanding. But isn't it like well known that like police generally have a database of like who they think in the town is drug dealing, who they think is like maybe breaking other laws. Like they might not, like the police generally, like they might even be tracking. I think with shoplifting they do this. They'll track shoplifters until they hit a certain amount, and like it's not beyond me to think that we have data saying, look, we know these people are here illegally, and that they're not still not actively making that arrest, but then they can get the trigger to do that and it's still valid.
That's possible. And if it was just the detention of these people that was like, so if ICE was just detaining these people on those grounds and they just stayed in detention, then that would be a separate thing. But it kind of feels like if we're playing on that analogy, it feels like the police have a system of determining that these people, may be involved in drug dealing, and then we're putting them in prison on that determination, and then not giving them the ability for that to play out in the court if they so choose.
Right.
Like the detention isn't necessarily the problem; it's the detention and then the deportation a day later.
Right. So I'll agree with you. There's a spectrum of like cases here, right? You'll have cases where it's like, hey, we suspect you're Tren de Agua because you have tattoos, right? And we just like arrested you for, we think you have the tattoos in our database. And then there's some where it's like, we got this group of guys, terrorizing people outside the apartment building in Colorado, for example, right? Mm-hmm. And so like, there are some cases where it's like we're very certain, where like I think you'd be able to easily convince a jury, you and I would be easily convinced that the evidence shows that this is a member of Tren de Aragua, right? Like this person is a member of a gang, this person is subject to deportation, perhaps not under the Alien Enemies Act, but still subject nonetheless. Even this case, I do believe, and it is my understanding, that they have a hearing to challenge the facts of their case, that they are who the people are being arrested. But this is a case where it's like, look, we have on record this evidence. It's very convincing. The government's basically like the government in a lot of cases can and what's it called? There's a legal term for this, but like where it's like there's overwhelming evidence that it's just like a stipulated, basically. Like we can stipulate like you're a member of Tren de Aragua. Maybe they even confess in some cases, right? And so in those cases where it's like, okay, the court's basically established under whatever determination process they have that you're a member of Tren de Aragua, right? You do not qualify for this asylum. You're subject to this. And then they expedite that process to deport them the next day. I don't have a problem with that. But if we're looking at this case by case, there's going to be more sympathetic cases and less sympathetic cases, right? Mm-hmm. So like I am open and interested in like looking at this. Like I said, I'm always open for having eyes on this stuff. Like I'm never like, oh, they just trust the government, they'll do it fine, they'll do everything fine. Like I obviously get that. Mm-hmm. But generally speaking, a lot of these cases, I think, especially when we're talking about the Alien Enemies Act, where it requires some sort of determination that you're a violent threat, I actually do like kind of want to get these people out as soon as possible, and I do want to have this process work as like very effectively and efficiently without abandoning the principle of minimizing essentially with like a zero tolerance policy, right? Doesn't mean it'll never happen, but a zero tolerance policy for mistakes, right? As in like we want that due diligence met, we want that identity like for sure proven. We don't want to like make mistakes and like get the wrong people and stuff. But in a lot of these cases, I think it's like we have them on a list. We know that they're a member of a gang. We have established like very convincing databases that this person's a member. Maybe we've deported them before, maybe we've fingerprinted them before. Like maybe we've like there's a whole host of cases, I guess. But would you make the argument that even in those cases where you and I might at the end of the day agree that this is like an egregiously like evil gang member that we would support deporting back to El Salvador, that this like process is too quick for them? Like, or that like
I would argue that this process is too quick for them, but that doesn't mean that I would argue for letting them out of detention. I think detaining these people like within ICE or having ICE detain these people is perfectly fine. It's just a matter of having them able to challenge that designation by ICE and challenge their detention before they're basically loaded up onto a plane in a day, without like being told the nature of their deportability.
I mean, I agree with you. It's my understanding that they still have those opportunities even under the Alien Enemies Act. It's just that it's expedited, and I'll admit, in my understanding of this, I don't know exactly what takes place in this hearing, right? Mm-hmm. Like, what do we know about these hearings that says that it couldn't take place, in one day?
So I would say that
even without them present.
I would say that the case law for the Alien Enemies Act does outline the fact that like people who are, detained under the Alien Enemies Act do have these certain rights. But I'm arguing that Donald Trump's administration, through these certain deportations, did not adhere to the rights that these people are allotted. That's the argument I'm making.
Well, that's also the argument of the JGG case.
Yes.
Okay. And I know we said that was dismissed because of venue, but is that being relitigated in the correct venue? Do you know?
I'd have to look up if there are current like habeas claims from all 5 plaintiffs or any more plaintiffs from the JGG case, but I'm not personally aware of them.
Okay, because I'm willing to say, I'll let it stay in the air for me until that case is answered, because there's a lot of nuance in this discussion, right? Especially when we're talking about due process. It's like a very there's a whole host of questions when you get to this, like what is due process? It's different in nearly every case. It's not like a single defined like due process is a hearing plus a jury trial plus like an attorney. Like in some cases it does involve a trial, right? Like in criminal due process there's a higher bar than in civil due process, right? Or in
or even I think the due process.
If they were going to arrest and imprison in federal prison an illegal immigrant from Trinidad, law, they do still have those due process rights against criminal punishment, right? And I agree with you there. I don't want people to not have due process, even if they're the horrible criminal from overseas. But when it comes to the civil resolution of deportation, which is a civil consequence, that bar isn't the same as it is for like a citizen who's being deprived of right for liberty, or someone who's being subjected to a criminal punishment. And I think I was watching some breakdown about this, that the court could reinterpret deportation as a criminal punishment, which would be a nightmare for me, because that would basically make deportations like impossible. Because
I think
you'd have to literally take every single one to trial to prove that they're illegal.
I was watching the debate on Tim Pool between, I think it was Good Logic and Pisco, and Good Logic, I'm taking it as his word here. He might be wrong. He may have completely mischaracterized it. I don't know. But he said that basically deportation doesn't, or like there's SCOTUS case law to show that deportation doesn't constitute punishment, so that would probably cut towards your argument. But the case law that does exist specifically pertaining to the Alien Enemies Act, JGG versus Trump, now one of them, shows that these people do have like the right to notice of their deportability and the right to challenge their deportability under a habeas petition. And I don't think
they're claiming that, right?
Well, that's what
the habeas petition is different than
that's what the Supreme Court ruled, is that the venue for, because it was when the TRO was challenged up to the Supreme Court, because Boasberg put the TRO basically saying that you can't deport the class under the Alien Enemies Act, and then the Supreme Court ruled that the venue of a class action doesn't fit for alien enemies deportations, and that their cases need to be brought in a specific cases need to be brought through habeas, and there can't be a class action lawsuit to challenge the deportability of all of these people. But it also ruled that these people have the right to notice of their deportability and the right to challenge their detention and classification.
I agree with that.
Alien enemies. I agree with that too. There's some practical questions about like if habeas is an effective way to litigate this, but I'm not, I'm not classified, or I'm not, smart enough to have that discussion. But from what I know about the details of the JGG, lawsuit and what has been, presented by Boasberg, it doesn't feel like Donald Trump complied with those rights to notice, and it doesn't feel like that you probably need the right to notice in order to enact your right to challenge.
Well, I don't know the case facts, so I'm not gonna. I guess I won't take a position on that, and I'll let the court decide if they end up relitigating it. But I guess
also something to keep in mind
I just have questions about it, like that. Like there's just those questions that I had earlier. I just like those are going to be what I would have to answer to really. Yeah. I guess maybe take a stance on this before the court did. But
there's also something to keep in mind in that Boasberg put the TRO to prevent the class from being deported, and now the Trump admin is being Boasberg found probable cause to hold the administration in contempt for violating the TRO. So that's also something to keep in mind.
That's part of the ask in the case. What you said? Sorry.
So Boasberg put a TRO to prevent
Right.
to prevent the deportability of this class.
Under that act.
That TRO got appealed up to the Supreme Court and ended up getting removed. But it was still found, probable cause for contempt was still found of the administration in that they were deporting people in the class, even though there was a TRO to prevent them from deporting people in the class.
Okay, I see. Okay, yeah, that's interesting. I guess it's about violations of TROs and stuff.
Yeah, which is a separate question. But
yeah, and there are times where you can violate a TRO if I'm not mistaken, because the point of a TRO is to prevent and this might not be applicable in this case, but this is like in other cases, there's times where like the purpose of the temporary restraining order is to like say we have a dispute, right? And it's like trying to settle this dispute could put one of us in a position that you can't recover from it, right? That's like in theory the purpose of the TRO. I think if I'm not mistaken, I probably am actually now that I think, but I can't think of any examples. But like if you could justify in the past or like later on that your violation of that TRO protected you from that, I'd wonder if you could make that argument.
So the only case law that I'm
just thinking out loud right now. I'm sorry.
No, you're good. The only case law that I'm familiar with is Walker Birmingham, which said that like even if a TRO is later overturned, you still have to like you're still legally obligated to follow that TRO, even if it ends up getting overturned later, because a judge's word shouldn't be questioned by the people applying.
Right. Well, not to derail, but this is a similar scenario in law that I'm aware of. In different states have ruled this differently, but in my state, Maryland, actually, I don't remember exactly which side of this my state falls on, but states hold this differently, where if you resist arrest, and then it turns out that there was no valid arrest, you can't be charged for resisting arrest. You can't be charged for just resisting arrest when like the other charges are dropped. But in some states, you can.
Yeah.
It kind of feels like that's like the logic is like similar, but I'm just yapping. I'm sorry.
No, yeah, you're good. That is interesting. I don't know the laws in my particular.
It is interesting, right? Because if you and I agree with it in principle. If the police are making an arrest, because here's the why I think the principle overlaps. You should generally expect that people. Like if it was like, hey, it should be illegal to resist arrest. That makes sense. You know what I mean? Like especially with a valid arrest, it is illegal in I think all states to resist arrest with a valid arrest.
Right. Yeah.
Right. The problem is that when those arrests are turned out to be not valid, you can say, hey, that you can't charge me with resisting arrest because there was no valid arrest. I
think the problem is that if we open the door to that, especially in like a legal context, then we're basically letting whoever is subject to the TRO, question the judge until the course is the case is finally litigated.
It would be we're giving the president a little bit of an upper hand over a judge, which I would actually agree with based on just like how these the accountability structures for these two parties and how they're both put in. I think that the president probably has a little bit more of a right to make decisions than a random federal judge, but at the same time, like this would be only applicable in cases where the president later is justified and says like, look, the TRO was totally invalid, thus you can't hold me to account for it. You would still have to prove that nothing, like that he was totally justified in violating the TRO, that it was totally wrong, right? Like in those cases,
the problem
that's, the logic from this, like the resisting arrest thing applied here. It would make sense to me, but I don't know that that's ever how it'll work. I don't know that the
problem with that is if a TRO is preventing the president from like deporting this certain class, and then the president ignores the TRO because he thinks that he'll succeed on the case and then deports that class, and then he was wrong and he loses the case, and it was found that he should have been found in contempt for the TRO.
He would also be chargeable for violating the TRO, yeah.
Well, the problem is that now that the president is also arguing that if we wrongfully deport somebody, we can't bring them back, then that whole class that he deported, even though they were protected by the TRO, that he deported illegally, is basically just fucked.
Well, that's a different issue because it becomes like the moot question or like out of bounds, I guess, like theory. But that's
well, if Trump is making that argument about Garcia, then I think it like maps onto it would map onto this.
Well, there's an argument there. But I guess to stick a landing on this last sort of like fun topic, I guess that we're having. let's say a hypothetical where a judge puts a TRO on the president for something that the president's clearly, and like you and I and anyone would agree, ethically, morally, like allowed, obligated, entitled to do. In those cases, like where we can agree that it, like, because we pretend we're omniscient and we're looking at this like system as a simulation, right? So we know how this is all going to play out the whole time. In those cases, it might make sense to say, hey, look, if the president violates a TRO and it comes out that that TRO was absolutely out of bounds, misplaced, and incorrect, the president should not be held accountable for violating the TRO. If it does come out that that TRO had any validity, like remote validity, like the tiniest speck of validity, then you would be accountable for violating the TRO. But the principle would be take the current, like immigration due process question out of it and replace it with something that we're like, the president needs to be able to do this. President's gotta be able to, like, say they put the president on a TRO to not speak with foreign powers, right? Just like, hey, we're some investigation, or you're being sued for something, and we're putting a TRO on you that you're not allowed to speak to any foreign leaders for like 20 days or something. And the president's like, the fuck? Like, I'm the president. I can't not speak to, there's a dumb example maybe, like, right? But I guess the principle is like, what do we do in cases where a judge is overstepping? A judge is making an error. Like, the judge is the one in the wrong.
You'd probably,
because I don't know that, Huh?
My guess is that you would probably just have to go through the appellate process. Because I mean, like in specific cases like that, we could probably make like individual justifications, but like as like a systemic rule, we probably don't want to set that precedent that the president could just ignore TROs, and then if he like irreversibly fucks up, that it's just like, oh well, that sucks.
Right, but on the opposite side, we're allowing a judge to make an like irreversible fuck up, and they're not as accountable as the president is. They're not as like exposed to like public scrutiny as the president is. They're not like placed into that position in the same way that the president is. I would say, like, if you were to put these two people side by side and say, like, which one of these, when they have a dispute, should have the final say, and I would say the president, but that doesn't invalidate like the value of the debate between the two, saying like what the, like it doesn't invalidate the litigation between the two, but it's just say, look, when there's like a dispute, I think we have to err on the side of the president. And that doesn't mean that the litigation can't occur and that we can't decide what the truth is, but I'm more worried about a situation where a judge prevents the president from doing something that he should be entitled to do, and then we suffer damage from that, than a president doing something and then the reverse. Sorry, my fucking brain just fried itself. But then the reverse, you know what I mean? Like,
I think
that seems to be more of a concern for to allow a judge to have that level of influence than to allow the president, who is already expected, entitled, and established with that level of influence. Like, that is the whole purpose of their role, is to have that level of influence. And when you let the judge interfere with it, that seems like that's the concerning area, because now it's like, now we really got to look at who's in these judges positions. Like, how much power do you have when you're a federal judge now? And like I said, this is something we got to separate from the due process and deportations thing, even though that is certainly like related, because that's the current debate. But the structure, I guess, is still like in question. Like, how do we set up this system to, like, where does the accountability lie? How does the structure work? I think there's something to be said about, like, if the judge is wrong, like, that's, I'm not willing to take the damage from a judge being wrong as I am from a president being wrong, because of the way they're put in that position, the level of accountability that they have, like the level of authority that's granted to them. It's actually specifically granted to the president, and it's like superficially granted to the judge.
I
Like,
guess at that point I would just appeal
the judges.
At that point, I would just appeal
scope
to like likelihood to make that level of disregard, and I would say that a president would probably be more likely to exercise like a wild abuse of power than a federal judge would, because they also have more like motivation to.
Well, that's true.
It's
that
hard to.
is true.
It's hard to. That's a.
Well, this is actually a little bit. This is sort of like, this comes down to the common law, like separation of like the branches and powers, because we intentionally, like, the founders intentionally didn't give the courts enforcement power, right? The president has enforcement power, which is why the president can, in theory, ignore the courts, and then it requires the legislature to impeach the president. And like, it's not like rock paper scissors where it's like this branch over this branch. It's all like a fucking hosh-mosh of all these different oversights and stuff. And I don't think the president should ignore the courts, but I guess what I'm arguing is in a little bit like, it's the court can't enforce anything that they do. And they account for this actually in a lot of their rulings. When like I was going through law school, we run into it a lot. The court will like acknowledge like, we can't enforce this, right? And sometimes it's like just too logistically impossible to enforce. Sometimes it's just like, if the executive doesn't want to enforce this, we can't enforce it.
Well,
isn't
that part of
with cannabis law? I mean, we don't enforce it, but it's still on the law. It's still on the books. It's all still law, right? But like the executive branch is like, if they took it to the judicial branch, they could still charge people, which would be insane, like especially now. But like they still could take it to the judicial branch and be like and charge people, but they can have that discretion to, do that and stuff. But I guess that's more of their check on the legislature to enforce those, because the legislature's provided that law, not the justice. But
yeah.
Anyways,
all right. Well, I think until more plays out with JGG, or unless like you find out something that I might have like misrepresented on accident or whatever, then I think that's probably wrapped up. I don't know if we can go anywhere else with that.
I would say I'll just to put my quick thing in there. The only thing I think I want to look at is exactly how these lists of subjects for these deportation flights that you mentioned, and like how this is like how are we making those lists? How do we know who to put on them? How is that process? What process did we have before we knew who these people were? Because depending on the answer to that question, I might be closer to siding with you.
Yeah, and all I have is like my general impression of how it was made by the way that it was framed by the plaintiff, so that's obviously going to be biased. But I mean, I'll definitely read into that a little more. I would also encourage you to read into it a little more.
I will. And we can talk again anytime. If you hit me up, let me know. I really enjoyed talking to you. This was fun.
Yeah,
great.
So what time are you going to Gibbs?
8:30.
8:30. Okay. Do you want to talk a little bit about Garcia?
Sure. Yeah. I mean, I'm just chilling.
Okay.
Yeah.
I think a lot of people get their priorities on the Garcia case kind of mixed up, because I think lumping him into the Alien Enemies Act deportations and making the due process claims about Garcia is probably...
Well, was he deported under the Alien Enemies Act or not?
No, that's why not to my knowledge. I'm pretty sure no. But that's why I think that like certain people on the left lumping Garcia in with the JGG class action, or with like the people deported under Alien Enemies Act, I think is not good. And I think a
lot of people that are just barely paying attention, like it's right, yeah. That is how it happens to be. People, and I'm not trying to blame people, but it's like a casual understanding, and it's not like people are. I can understand how a person who's like not super into politics would just kind of like mash them together in their mind and think it's all the same. Yeah. Especially because of the whole MS-13 thing with Abrigo Garcia. I could see that. But
and I agree with you. I do think it speaks to the mindset of the administration a little bit. So if you want to incorporate it in that sense, then maybe you could. But I think what needs to be isolated when it comes to Garcia's case is the Trump administration's like willingness to basically ignore the law. So like when it comes to the administrative error for deporting him, even though he had a withholding order, I think that was bad, obviously. And the fact that he was deported was obviously bad. Even if we grant that, he had some shady shit going on, he's probably not like a good hombre or whatever. I think we could probably grant that like them ignoring the withholding order was bad, because then it like, if we set the precedent that presidents can ignore withholding orders, then we set the precedents that withholding orders mean nothing. And then that was bad enough, I think. But then following the fact that SCOTUS ruled that, they must facilitate his return, and that, Donald Trump is kind of signaling that even if he does have the power, he wouldn't do it because he's a bad person. I think that is starting to make a really uncomfortable relationship with the judiciary.
There's a very different question between the withholding order thing and with the question of what the courts can do with Abrigo Garcia already being back in his home country.
Yes.
So they're like totally separate questions in my mind, legally speaking. Like one of them is Abrego Garcia is a citizen of El Salvador.
Mhm.
That is, he is not an American citizen. So when he's back in his home country, the court, and this is part of that separation of powers we talk about, the court, just like the legislature, cannot direct how the president uses his presidential powers, right?
Mhm.
And so the reason that this becomes an issue is because they say you have to get Abrego Garcia back. That's the remedy under the court. You have to get him back. Does this mean that if, like, I mean, it's impossible for the president to be handed a negotiation goal and then be told to meet it, because now it's like, okay, what if they demand $10 billion for him? Does he have to pay $10 billion under the court order? He has to do that. Like, how does he meet the negotiation standard? How does this, like, that issue is a separation of powers issue. It's separate from the withholding order issue.
I agree.
Trump not remedying this case, because in some cases when you don't get the remedy, it does open the door for that remedy to not be applied in future cases. And that is the concern that I would share with you. But what I don't think we see here is that this error, by not being remedied, is going to result in other withholding orders being ignored. We have established that the withholding order should have been honored. It was incorrect to not have honored it. The reason that I bring it up is because people will, and the hyperbole that I'm pointing out is that the hyperbole is that, like, oh, this man received no due process, like this order, whatever. This is it's like a ref making a bad call in a basketball game. This is kind of how I described it in my video. Like, it's the wrong call. It doesn't invalidate the fact that we had refs for the whole game. It doesn't mean that we had no rules in place for the whole game. I think that the withholding order should have been honored. That being said, I don't know that I agree with the withholding order itself, right? I may not have agreed with that being entered in the first place. And when you look at this case, if you didn't have that withholding order, you take that out, you still have this entire process where they litigated his membership of MS-13, the case of this 2022 traffic stop, which, you know, was a traffic stop, not an arrest or, you know, anything like that.
But it did look bad, right?
It is, I mean, it's like the tattoos being litigated is very minor when you look at this, because it's like, okay, what's the innocent explanation for this, right? Trafficking people from Texas to Maryland in a car owned by a guy who's incarcerated in federal prison for human trafficking. Like, it does look horrible. But so without the withholding order, he would have been validly deportable under due process, and that's why he was deported. That's how they even knew to get him. That's why he got arrested. Like, that's how he was on their radar. That's what happened. So that's the hyperbole I'm pointing out. I can acknowledge the error. I can acknowledge that if Trump was in a position to facilitate it, he would have to do that. But the reason the court worded it so carefully is because they understand that even if the remedy is that Abrego Garcia should be returned to the United States, when it comes to ordering the president to use his presidential powers, there's just a straight block on doing that.
Yeah.
And so if Abrego Garcia were to be returned to the U.S. by Bukele, right, he would have to, under the law, the process for him now, under the court system, under the process that he's being offered, would be exactly what the court said. They'd have to facilitate this, you know, restructuring of whatever process. But the El Salvadorian president saying, I'm not going to give him back. And I'll admit, I have no doubt in my mind that, like, the day before this meeting, Trump was like, hey, you're not giving that guy back, right? And he was like, oh, yeah, no, don't worry about it. And they're like, that's my guy. Like, you ain't fucking me up, dog. Like, I get that. Like, 100%. If Trump wanted, I mean, we get, like, hostages out. Trump's like, we love to brag about Trump getting people out of places that don't want to return people, right? Like, all the time. So it's not like I can say, like, oh, Trump just can't get him back. There's just nothing we can do. But at the same time, like, there really is no way for the court to order that. And that's why he's going to get away with this case. And I also think there's an element here that is probably bad for the left on this issue, just narrative wise, because ultimately what it's coming down to is that this looks like a minor error, and errors sometimes need to be remedied. And sometimes it's like, okay, it's a minor, we can let it slide. And in court, we call it a harmless error, right? There's errors made in court cases all the time. Doesn't invalidate your due process unless it can be shown that it materially affected the outcome of your case, right? So we have times where we admitted errant evidence, or like we didn't allow this, you know, argument to be made, or some jury instruction was errant. But unless you can show that it materially altered the outcome, then it's, you know, the due process was not affected, right? And the things will stand.
So I guess the thing that I want to isolate to here is that I agree that the courts can't say, hey, you need to offer up this amount in order to bring this person back. That would obviously be a case of judicial overreach, or even saying that
they
you
can't
need
set
to
a negotiation goal, or
right,
like
yeah.
they can't.
But the problem is that if they're saying they must, facilitate the return, the two things that I need to have, shown to me is that, one, there isn't an understanding with we are paying people to house them in El Salvador. So my understanding would be is that if this is like a transactional relationship where we're sending people and money to house these people, that we couldn't request one of the people back. That feels strange to me. And then
I think you're confusing, respectfully, that when they say that he must facilitate it, that they're also implying within that, and maybe you're right. I'll admit that. Maybe you're right, but I don't think you are. So I'll say it. But I think that what you're assuming is that when they say facilitate it, that also implies that he must attempt to do it. That he must, like, in some form, facilitate implies that he must actively try something in that pursuit.
Well, the problem
if that's how the court understood facilitate to mean, then you'd have a good point. And I'm not saying they don't. Like I said, I'm not like an expert in this sort of immigration law, but my understanding is they say he has to facilitate this. That doesn't mean that he has to even make an attempt. It basically means that if it's put at his door, like if it's brought to him, he would have to do it. That's the only situation where he would have to do anything.
So
because they've acknowledged that they can't tell him what to do when it comes to the foreign powers. Because again, this is separate than domestic.
What the Supreme Court ruled in Garcia versus Nome, the order to to facilitate his return, was actually that they must. It was on the grounds of a district court ruling that they must effectuate and facilitate Abrego Garcia's return. And within, what was it, like 14 days or something like that. That got appealed up to the Supreme Court, and the Supreme Court said, okay, the 14 days thing obviously isn't applicable because it's past 14 days, so we can't say that you had a legal obligation to bring him back without appealing. So that part of the ruling was pushed aside, but it said that you must facilitate his return and effectuate his return. But what effectuate specifically means, because it was kind of vague in the original district court's ruling, gets shot back down to the district court. So what the Supreme Court did rule was not only that they must facilitate his return, but also effectuate by the terms that the district court lays out.
Okay. So effectuate and facilitate. Facilitate means to manage it. Effectuate would mean to... What is this like? They effectuate as in... Here's the process that you're resuming with him, that you need to get him back into this position, right? Mm-hmm. I don't know that still requires that. Effectuate is closer, though, to implying an attempt is required. But I don't know that an attempt requirement would be equally, like, in the same vein as telling the president what to do with his official powers. So the question, I guess, is, can an attempt requirement be made on this, even if he's told to facilitate it and effectuate it? The word effectuate, because everyone's been focusing on the word facilitate, but effectuate, it does get closer to what I guess we're talking about. So perhaps there's a good point there.
I'm pretty sure there's also potential contempt hearings in the Garcia v. Nome. So my I don't know the specific terms that was laid out by the district court in what effectuate means, but it's my understanding that what was laid out by that district court in regard to what effectuate means, the Trump admin is not adhering to, especially since this is kind of unrelated to the case. But I'm sure you saw the recent interview that Trump did with, who was it, CBS? ABC, where the anchor basically asked him, like, okay, why don't you, like, pick up the phone and request this even just request this person back from Bukele? And he said, if he were the gentleman he said he was, I would do it. Which basically tells me that he hasn't even, like, considered taking a step. And the reason that he isn't taking a step isn't because he believes that there's a legal question over, separation of powers or whatever. It's just because he doesn't want to, because he thinks he's unsavory, which I don't think is meaningful. I don't think in almost any world that would be viewed as
it's a discretion call from the president, I guess. We could debate the legitimacy of that sort of discretion call being made by the president, but it's the effectuate effectively means like what do they have to effectuate? Whatever he's told to effectuate is the final result being requested, as in the ultimate position that Abrego Garcia would be reinstated to. That's what I understand that to mean, and I don't know that I'm, like I said, I'm not coming into this discussion with like a super expert. I haven't read all these cases through. I'm just coming in with my understanding of like constitutional law and due process.
Mm-hmm.
But effectuate and facilitate, especially in the context where they clarify that like you can't really set goals for negotiation or like require the president to ultimately accomplish something, but you can still say, hey, this is the process that should be honored, or that this is what you would be required to do in the applicable realm, which would be domestic, right? Not in with foreign territories and foreign citizens. It seems like Abrego Garcia is one of those cases where Trump would make this correction if Abrego Garcia was it's kind of funny. I think that's a good point. Trump made a good point there. If Abrego Garcia was someone that was like a stand-up guy and that we really felt positively about, like, Trump probably would and could and should and would do all of this. But something tells me, and that something is obviously the 2022 traffic stop, but something tells me that Trump might have more information on this guy than what's been made public. And I've been wondering if this is going to get closer to the election and Trump's going to drop some heavy fucking, I mean, seriously, if we know about this 2022 traffic stop, and the feds told the state troopers to let him go, by the way, is a minute detail that I thought was really fucking interesting. Not going to go into that rabbit hole, but this could be really, this could end up backfiring, I think, for the people who postured and went with the hyperbole defending this guy, because even if there was a case where this was sympathetic and like we would agree that this guy should come back, it's not going to be, that argument won't sit very well, I don't think, with a lot of people if it turns out that this guy's imagine we just had evidence that he committed murder in the US. You know what I mean? Like, we're like, we solved this murder that took place and we have evidence and we believe it was him, and like it's this, citizen in some state and it was some hit and some gang or something or whatever. That is a case where I would say, yeah, the president shouldn't stick his neck out to remedy it for him. Like there's a spectrum there, I guess. To wrap that up, there's a spectrum of like a sympathetic case where I think the president should and would and could intervene in this exact decision, and then some where he could say, look, I hear the decision, but I'm not gonna put my effort in for you guys. I'm just gonna let you guys make that legal ruling, and that'll just be it.
So I guess
I actually agree with the discretion here.
I guess what I would appeal to is that I'm not necessarily, I don't see myself as defending Kilmar Abrego Garcia necessarily, because it's my opinion that even if they did effectuate his return, they did bring him back to U.S. soil, they could just detain him and challenge the withholding order and then deport him again. Like that, I have no problem with that. Or deport him to a different country if they don't want to, appeal the withholding order. They could just deport him to a different country with a different holding thing. I wouldn't have a problem with that. And I'm not doing this out of the goodness of my heart because I think Kilmar Abrego Garcia is such a good guy. I'm more so attacking this just based off of an adherence to rule of law thing. I'm reading here, and I don't have a lot of the context, but basically that the Fourth Circuit basically upheld that the Supreme Court decision doesn't allow the government to do nothing. It at least has to take a step. It seems to me that if the district court said that they have to effectuate and facilitate his return, the Supreme Court basically kicked back what effectuate means, but then said, yes, we do have to facilitate his return. And then the Fourth Circuit said that the current Trump administration's interpretation of what facilitate means is not the way that the courts are viewing the word facilitate to mean. If we have all of these different legal bodies in different stages of the political process telling Trump, hey, you need to do this, and then Trump is basically doing presidential discretion to say that I know that I've been ruled to do this, but I don't want to. I think that sets a really, really bad precedent.
Well, that's not it wouldn't even be setting the precedent. That is the precedent. So, I mean, and this has been different areas of law, but presidents this wouldn't be the first time that a president's I think Biden even talked about ignoring the court on student loans. So there's precedent with the reading in certain interpretations in different ways and stuff like that. I don't think that this would be like a totally brand new precedent. But to challenge you on the whole like I agree, I want the rules followed, I want to dot the T's, dot the I's and stuff. But I think a part of this frustration, maybe for my side of this debate, is coming from the people who seem to be making that argument. We had just met you, so I'm not. Forgive me if I project the entire left onto you.
That's fine.
But like people who backed up sanctuary cities, who have allowed the illegal immigration problem to grow to this scale because of asylum fraud, because of people refusing to go through the due process when they get here, people who are here illegally and failing to appear, like there's. If we're looking at the immigration system and due process as a whole, right, and we're saying where are the errors and faults in this, it seems to be obvious to me that the due process errors and faults in our immigration enforcement system is that it's not deporting anybody, that we're like the issues are that people aren't appearing at their cases, that we're having too many people that are like granted asylum claims that don't qualify, and then they are been here for 2 years and then they get, you know, they don't qualify and now they're subject and we don't know where they are. Like we have this Abrego Garcia mistake, but this isn't even like one of like 100. This is like a pretty unique error in as far as I'm aware. Like he's not example of like one of 100. Like this class action suit, I guess you could make the other claim because that was a group making a similar claim. But with Abrego Garcia, for example, it's like this idea that like we're gonna scoff and like freak out about the system now seems really like. This is why I think it comes naturally to me that to think that this is ideological and coming from a place where people just don't want to enforce immigration law or deport people, because the issue seems to be obviously that people who are here illegally that would be validly deported are almost never deported.
Yeah, sure. So, I mean, me personally, because you don't have a whole ton of background, on who I am, I don't even necessarily like super align myself with the Democratic Party. Like, obviously there are different like policy goals of the Democratic Party that I don't super support. And like I said, like most of my political, alignments are just on the grounds of like protecting rights and not even necessarily like getting legislation passed. Now, I would be interested in talking about like that sort of politics, but I think we're right now at a point where defending adhering to the laws that are already laid out is more important than passing new laws that are just going to get ignored later. I think that like
what's your view on sanctuary cities? I mean, were you supportive of those or did you oppose those?
I would say generally opposed, but I'd have to read into like specific things.
Well, because that seems like that's like a very blatant, clear affront to our immigration law and due process system. I mean, you're literally like interfering with our immigration law enforcement, right? And so like when we're talking about due process from that angle, it's like that's such a huge like that it's part of the reason I think that the scale of the problem has gotten so big. And like I said, due process is calculated in part based on how the government can effectively, while honoring, you know, people's rights,
the reason that
the facts of their case.
The reason I'm reserved.
Enforce the law.
The reason I'm reserved about that condemnation is that there's a states' rights question there. I'd have to see whether like I'd have to.
Well,
I
would disagree with that. There's definitely no question, because it's the supremacy clause of the Constitution that federal law, like this is actually, I would argue, established very clearly in law.
Well, that's what I'm saying. Like, I'm just not as familiar. I'm just not as familiar with the topic, so I don't feel qualified to answer that.
Well, that's fair. That's fair. And you might there might be a point.
That's why I'm like kind of hedging a little bit, is that if I end up, you know, ascribing to a states' rights argument, right, that I'm not going to undercut.
Well, you might have to do more looking into. Just to think out loud and sort of take your side, just for the devil's advocate for myself. Mm-hmm. Perhaps it's like what we were talking about, where the president can't be ordered to do certain things. Like we can't order states to be like, use your enforcement arms to do federal immigration law.
Sure. Yeah.
Maybe there's a claim there, but at the same time, I think that when it comes to like the states' rights question, generally speaking, this debate would fall under the structure of the supremacy clause, which is well established that the federal law on immigration supersedes the state law and that it has to be enforced. But I guess, like I said, I'm not in law enforcement, and I'm not gonna debate bro you and just assume a position.
I just have to see
who knows how that structure works.
I'd have to do more reading on it in order to feel comfortable commenting on it. That's the general idea. But as it relates to what's currently happening. I think I'm much less sympathetic to Trump's willingness to adhere to the law anyway. So I think I do view Trump's engagement with these deportations much more sinisterly, because just as a little background, like one of the main reasons why I got into online politics was because I thought January 6th was a really big deal, and I felt that no one like adequately dealt with the consequences of that. So that was one of the main reasons why I started talking about this in general. And I'm a young guy, so I mean, like, I wasn't super engaged in the political process pre 2020. So like, I know there's claims about like Obama doing executive overreach that I'd probably be not sympathetic to, and obviously Bush, and obviously Nixon.
Sure.
But I think like where I started becoming politically minded was around 2020, and then more so the election in 2024. And I've been paying attention to a lot of things surrounding Trump, and it just makes me be very pessimistic with the idea that he has any will to adhere to the law, basically.
Okay. I mean, I hear you. I disagree, obviously, but that's all fair.
Mm-hmm.
Hey, hit me up anytime. I like talking to you. So I don't know if we can keep talking. Like I said, I'm just chilling, so I don't know if you have plans or anything.
But not super particularly.
We covered that. Good topic.
Yeah, I think it was a good talk. I've got stuff to read up on. I think.
Yeah.
I'm not going to pigeonhole you into a January 6th conversation right now, because that's something that...
I mean, we can talk about that sometime if you want. I mean...
yeah, if you want to organize something, that'd be great. But I mean, that's probably going to be a big, long... that's going to be a much longer topic and a much more...
Sure. Yeah. Well, I live in Maryland, so I know a lot of people that went. I remember the day of, because I remember talking about it with people at work. So I have a not having been there myself, but having been... like in the area and knowing a lot of people that went down there, I feel maybe it could be an interesting conversation for sure.
Yeah, I'd love to have that conversation at some point, but it's the
we'll save it. No worries.
I think yeah, I don't know. I feel I just to close off, because I am gonna go. I do think that Trump generally does. I don't know if I'd be strong enough to say that he has a contempt for the Constitution or a contempt for the law. But from the way that I have perceived his actions, particularly around January 6th, particularly around like the way that he ended up treating the fallout from January 6th and the prosecutions and stuff. Obviously there's the famous terminate the Constitution to rerun the election line.
That'll be a fun one. We can talk about that.
Yeah. I think that I just...
because I agree with that. And I've got this tattooed on me. That's a fun debate.
Well, we can have it another time, and that would be...
Yeah. Well, I would say it's just to give you my quick thought on it. It's basically the principle that our founding fathers told us, that if the government is corrupt, we have to overthrow it. And what in theory means is that even if it's illegal, we have to overthrow a corrupt government, even if it's unconstitutional, even if it's illegal to do so. The principle is the government's corrupted, that you overthrow that. And if they do reach that point, that's like an obligation we have. But at the same time, like, you could easily make the argument that we're not quite there, maybe. But maybe you could make the argument that we are.
The argument I would make, obviously, is that, like, in cases of like giant executive or governmental overreach, like, it's not a very American opinion to say that an insurrection is never justified. But I would say that it wasn't.
Well, I would also say the thing with the January 6th, and not to get into the political stuff of it, but one of the narratives following it was like, oh, we can like never let this happen again. And I'm like, well, hold on a second. I'm not necessarily all about the government making it impossible for an insurrection to happen. That doesn't in theory, that sounds like kind of a closed door for us, which we were supposed to not close according to the founding fathers. But I don't know. I just think that's funny. I just wanted to mention that.
Yeah.
But we can talk about that for sure. It's fun.
Yeah, I would love to schedule something there. Although,
I stream like nearly every day, so
I get a little more aggressive with the J6 debates. So hopefully we can keep the preaching.
No worries. Hey, I'm not. I don't know. This is like my favorite. Like, I'm gonna this is a highlight of my week. Streaming wise, was having this conversation with you for sure. So I appreciate this, and I really like this.
Yeah, I appreciate the conversation. If you ever have if you found out that something that I said today was wrong, feel free to let me know. I like being right, and I hate being wrong.
I'll dunk on you in a YouTube short. No,
yeah,
just
go
kidding.
for it. Listen, go for it.
Nah.
Yeah. Good luck on Gib. Listen, be nice to my man Non-Fawn. All right, I love that little guy. All right.
We'll see.
Be gracious
We'll
to
see.
my guy.
Nah, you know what? I like you enough to say, okay. I
All
will.
right. Thanks. All right. I appreciate you talking.
Hey, thanks. Nice talking, man.
Yep.
Take care.